Okay, I think we can start our event for this evening, afternoon, morning, wherever you're joining us from. So, good evening, good afternoon, good morning, wherever in the world you are joining us from. I'm Dr. Meagan Wong. I am a lecturer at Essex Law School, where I'm also the founding director of the LL.M in International Law degree. Together with Dr. Emily Jones, we are the co-founders and co-conveners of the Public International Law Lecture Series, and we are really delighted to have you join us today. For those of you who are joining us for the first time, Dr. Jones and myself are pleased to present the Public International Law Lecture Series, and for those of you who have attended our events before, welcome back. I'm very pleased to be your host for today's event with our speaker, Dr. Sujith Xavier, who will be chaired by Dr. Emily Jones. I will defer to Dr. Jones, our chair, for today to introduce our speaker. As your host, I wanted to speak a little bit more about the Public International Law Lecture Series. This lecture series is built upon two important intellectual traditions of public international law: formalism and international legal practice, international legal theory, including post-colonial and feminist perspectives. The idea for the series stems very much first and foremost from our friendship, and is inspired from our respect for each other's scholarship and research and our days of teaching public international law together. We're both generalist public international lawyers with several specialist interests, but we engage with international law from different approaches. I'm a formalist and Dr. Jones is a critical legal scholar. And the idea behind the series that we co-founded and co-convened very much brings forward cutting-edge discussion in international law from varied and different frameworks, theory and practice, to create what we really hope is something for everyone to enjoy on this little space on Zoom. But now let me introduce our chair and tell you more about our chair for this event. Dr. Emily Jones is a NUACT fellow based in Newcastle Law School, Newcastle University. She's a generalist public international lawyer whose interdisciplinary work combines theory and practice. Dr. Jones's work cuts across gender and international law, international environmental law, the law of the sea, science, technology, and international law, gender and conflict, outer space law, and political economy, imperialism, and international law. Her monograph entitled Feminist Theory and International Law, Post-Human Perspectives was recently launched and published with Routledge's Glasshouse series. And why don't I defer over to my amazing and beautiful friend, Dr. Emily Jones. Thank you.
Thank you. Thanks so much, Dr. Wong. It's a pleasure and a joy always, as ever, to be here with you today. And it's, my real pleasure to welcome to the series our speaker, Dr. Xavier today, who is, of course, the Associate Professor in the Faculty of Law at the University of Windsor in Canada, which is situated on the traditional territories of the Three Fires Confederacy of First Nations, comprised of the Ojibwa, the Odawa, and the Potawatomi. Dr. Xavier's research spans domestic and international legal theory, including third world approaches to international law, transitional justice, and Canadian public law and racialization. And he's one of the co-editors of the Decolonizing Law, Indigenous, Third World, and Settler Perspectives book, which was published with Routledge in 2021. He's also currently co-editing a special issue on race and racialization in Canada for the Journal of Law and Social Policy, and is, of course, a founding member of the editorial collective of the Third World Approaches to International Law Review, which many of you may know as TWAIL. He is active in the legal profession as a member of the Law Society of Ontario and has significant experience working with grassroots organisations in Sri Lanka. So we're going to get many of these aspects in this paper today as well. In addition, Dr. Xavier has appeared in the Supreme Court of Canada and the Canadian Federal Court and the Federal Court of Appeal. And at the Faculty of Law, he teaches legal theory to Master of Law students, LL.M students, public international law, administrative law, and race in the law to JD students. Today, he'll be presenting to us on the topic of reading transitional justice through a third world perspective. So just a very brief note on the question and answer before we begin. So we'll have a bit of time for questions at the end. And I imagine there'll be quite a few. I can see a few people in the audience who I know are working on this topic as well. So yeah, please do post these questions. You can post them at any time during the lecture, but I will be asking them of our speaker today at the end. So to ask a question, there's a little Q&A thing at the bottom of your screen. It's like 2 speech bubbles. So you just need to click that. If you would like to remain anonymous, you need to click like ask question anonymously. You'll see there's a little tab. It's quite self-explanatory. If you don't do that, then I may well read your name out, which is also fine if you don't mind that. However, enough of logistics. I know we're all eager to listen to the lecture today. So without further ado, over to you, Dr. Xavier.
Thank you, Doctors Wong and Jones, for this kind invitation to participate in your lecture series. Dr. Jones, Emily, if I may, thank you for that generous introduction. It has been such a pleasure to get to know you in the past few months, and I'm really looking forward to opportunities where our scholarship may align and where we can be co-conspirators. And Emily, thank you again for your help with the slides. If we can shift to the second slide, that'll be great. So it's with that, let me begin by saying that it is also a pleasure to be back, at least virtually, in the United Kingdom. I'm titling my talk, Reading Transitional Justice from a Third World Perspective. This talk comes out of several projects that I'm currently working on. The first is a book chapter for an edited volume by Third World Approaches to International Law Scholars. And I'll be using the moniker TWAIL to describe Third World Approaches to International Law as I proceed. The second project is my attempt to marry my interests in queer theory and critical race theory with transitional justice. And it's part of an ongoing conversation that I'm having with several folks in various areas of international law. And the third and final project that I draw from it in terms of this talk is the larger contribution that I have spent my entire academic career trying to formulate, which is to think about the relationship between international law, race, and violence. So in the next 30 minutes or so that I have with you, I want to first situate myself within this field that I plan to read. Queer people, and here if we can shift to the next slide, queer people and those working on critical race theory in our virtual room may know this technique of reading. And I want to spend the first part of my talk on this. From there, I'll quickly define the field of transitional justice and then focus on 3 specific areas within this particular field and offer my own reading of it. So let me get to this idea of reading. Reading is a term of art that is commonly used in popular queer mainstream TV shows like RuPaul's Drag Race. Before it was co-opted, reading was developed and used by Black and brown drag performers. The art of reading was first noted in the now famous but problematic 1991 documentary Paris is Burning by Jenny Livingston. Queer theorists have come to understand reading as an insider critique to build an armor against heteronormative forces that structure our daily experiences. Critical race theorists have also deployed the technique of reading, or what Bennett Capers suggests as reading back. For Capers, reading back is a way of reading. It's a way of reading critically, all the while thinking about the socio-historical context that locates the text in its current place and time. In a recent intervention on critical race theory, TWAIL and critical race theory scholar Professor Saira Akila Chowdhury builds on these reflections and suggests that reading back is a hermeneutic method. She goes on to note that reading back allows us to not only see sites of contestation more clearly, but also the operation of ideas that become assumptions, background facts that go unchallenged, and how they become normalized and commonsensical. It allows us to see sites and ideas that should be contested, but that may not be, and not simply those that operate like phantoms haunting the text in the background. And for me, this kind of quote really frames the way in which I'm thinking about reading. So in this talk, I'll be reading the field of transitional justice, both as an insider and an outsider, while drawing inspiration from these two methods that I have laid out just now. If we can move to the next slide, please. So I'm speaking to you from the traditional territories of the many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people, and is now home to many diverse First Nations, Inuit, and Métis peoples. This place that I'm now on is known as Toronto, Ontario, Canada. When I started doing this work, I was living on the traditional territories of the Three Fires Confederacy of the Ojibwa, the Odawa, and the Potawatomi, which is where I work as a tenured law professor. In Canada, it is now customary for us to recognize the sovereignty of Indigenous peoples and their sovereign claims to territory that many of us are on. Importantly, the recognition of their sovereignty then suggests that those that are not Indigenous on these territories are guests. I came to these lands as a refugee almost 30 years ago. I came in search of refuge because of my then home, the northern province of Sri Lanka, was affected by a protracted civil war between the Tamil separatists and the Sinhala Buddhist state. In both contexts, I occupy both an insider and an outsider positionalities. On the one hand, I fled the war and came in search of refuge and satisfied Canada's requirements to claim asylum. That said, my allegiance to the settler state has brought me in direct conflict with Indigenous peoples and their right to exist. I pick up on some of these issues in a forthcoming piece through the University of Toronto Press. Since coming to Canada, I have returned to Sri Lanka and worked as a human rights advocate in the Eastern Province. I have litigated refugee cases here in Ontario, Canada, and worked with grassroots organizations on the island. And when I say the island, I mean Sri Lanka, and within the diaspora, moving both as an insider and an outsider. As a law professor, I co-chaired our law school's committee tasked with overseeing the implementation of the Canadian Truth and Reconciliation Commission's 94 calls to actions. I raise all of these elements because I want to signal to my political commitments in thinking about mass violence and how to move forward. In this vein, my reading of transitional justice is one that is rooted to the field and one that is deeply critical of the field. I think the field needs to potentially change. It needs to become more familiar with the context and take account of the victims' perspectives. It also needs to take account of historical context that has structured the field itself and the events that people are trying to move past from. And this is my read of the field. Of course, this means that I may have missed important debates and texts. In that vein, I'm also ambivalent about the role of law in this field, and this field more generally. As I get more and more ensconced in the critical race theory literature, I can't help but think that we need to change everything. And here I'm drawing from the work of Professor Ruth Wilson Gilmore. But before I start providing a critique of the critique, let me shift to the second part of the paper, which is to define the field of transitional justice. If we can shift to the next slide, please. So the field that I'm thinking about and trying to read is transitional justice. Transitional justice is about how to move from past violence in varied contexts, ranging from post-authoritarian regimes to established democracies. It is a nascent field of scholarship, practice, and policy with contested origin stories. Some have suggested that the field emerged as a response to the gap in accountability following World War II, while others have sought to trace its origins back to Western civilization. There are numerous definitions of transitional justice. The United Nations understands transitional justice as encompassing the processes and mechanisms associated with a society's attempts to come to terms with a legacy of large-scale past abuses through accountability, justice, and reconciliation. And that's the quote that I have for you on the slides. Now, shifting to the next slide, according to the International Center for Transitional Justice, Transitional justice is a means through which countries emerging from periods of conflict and repression address large-scale or systematic human rights violations so numerous and so serious that the normal justice system will not be able to provide an adequate response. So now if we can move to the next slide, there are many ways of grappling with past violence. Taking a bird's eye view of the field, various perspectives and practices can be grouped into a number of themes. Themes such as accountability, reconciliation, truth-telling, reparations, and institutional reform. These broad themes enable the political and legal actors to achieve their objectives of accountability and justice through, for example, reconciliation. I'm framing my reading of this field through these themes because of the settled consensus in and around transitional justice. In this particular reading of transitional justice, I focus on three themes for today. The first is reconciliation, the second is truth, and the third is reparations. In setting out the contours of these themes, I rely on the work of international commissions, and in addition, I rely on the Canadian Truth and Reconciliation Commission's work and the work of the Sri Lankan Commission of Inquiry and the lessons learned and reconciliation. If we can shift to the next slide, I just want to say a few words about each of these commissions before I get into the specific themes. I thought it might be easier to provide a background to how these institutions came about before we jump into the arguments or my reading of these three themes. As I noted earlier, Canada is built on the ongoing genocide of Indigenous peoples. One of these odious elements of the practice of genocide was the act of removing Indigenous children from their parents, their families, and their communities. The removed children were placed into Western religious residential schools to face untold horrors through re-education. The last residential school closed its doors in 1996, not that long ago. This experience forced many of the survivors to seek justice before the Canadian courts. Considering the potential cost of compensation via the judicial decision of the Ontario Court of Appeal, the Canadian federal government agreed to create the Truth and Reconciliation Commission, along with a host of other reparation measures for the victims. So that's how the commission was set up. After hearing from the residential school survivors, the 2015 final report of the Truth and Reconciliation Commission detailed Canada's history of violence. Then the Commission's 94 calls to actions were directed at the federal and provincial governments, educational institutions, and civil society. And in particular, this is where educational institutions like the law schools in the country had to kind of take stock of how they were teaching doctrinal their approaches to the various doctrines that we have within the common law and also the legislative enactments. And of course, the calls to action spoke to or were directed at civil society as well. Now, shifting a little bit to Sri Lanka, the 2009 defeat of the Tamil Tigers by the Sri Lankan military ushered in demands for accountability and justice for the deaths of Tamil civilians during the war. Given the international pressure, the then president of Sri Lanka, Mahinda Rajapaksa, created the Commission of Inquiry on Lessons Learned and Reconciliation on May 15, 2010. The commission was tasked with looking back at the conflict and ahead for an era of healing and peace building in the country. After hearing from the witnesses, the commission problematically determined that the Sri Lankan military forces acted in a manner consistent with the position that protection of civilian life was a key factor in the formulation of a policy for carrying out military operations that led to the defeat of the Tamil Tigers in 2009. So that's the context from which I'm drawing from for my reading of transitional justice. If we can move to the next slide that focuses on reconciliation, then we can start thinking about reconciliation, which is the first theme that I want to get into. So reconciliation is a central animating theme in transitional justice. Reconciliation in its ordinary meaning is to end a disagreement and to start a good relationship again. This ordinary meaning, however, has extraordinary consequences when a community is trying to move from past violence. While pervasive in transitional justice, the meaning of reconciliation was recast with the creation of the South African Truth and Reconciliation Commission. Created in the wake of white supremacist apartheid, the commission sought to heal the country. In his opening foreword to the report, the chair of the commission, Archbishop Desmond Tutu, noted the following: "The commission has not been prepared to allow the present generation of South Africans to grow gently into the harsh realities of the past. And indeed, many of us have wept as we confronted with its ugly truths. However painful the experience has been, we remain convinced that there can be no healing without truth. My appeal to South Africans," Archbishop Desmond Tutu says, "as they read this report is not to use it to attack others, but to add to it, correct it, and ultimately to share in the process that will lead to national unity through truth and reconciliation." If we can shift to the next slide. In an analogous manner, the more recent report of the Canadian Truth and Reconciliation Commission, in hearing from the Indigenous survivors of the residential school complex in Canada, offered important insights as well. The Canadian Commission suggested that that reconciliation was akin to dealing with the brutalities of violence within a family. Reconciliation, the commission says, is about coming to terms with the events of the past that overcome the conflicts and generates a respectful and healthy relationship with the larger settler and Indigenous communities as a means to move forward. The commission formulated the following understanding that I've included in the slides of reconciliation. It says, in order for reconciliation to happen, there has to be awareness of the past, acknowledgement of the harm that has been inflicted, and atonement for the causes, and action to change behavior. These understandings of reconciliation point to a larger gap within transitional justice. And I'm framing this larger gap, or I'm reading this larger gap, as a place of settler colonialism and historical harms. There is extensive academic engagement on the linear direction of transitional justice mechanisms and their purpose. There is a specific destination that transitional justice has in mind: to move from a violent past into a democratic future. While the literature that exhumes these questions is significant, the erasure of the experiences of settler colonies is profound. This erasure has been illustrated by Indigenous and settler scholars living and working on the traditional territories of Indigenous peoples in what is now known as North America. In fact, Yellowknives Dene scholar, Professor Glenn Coulthard, has theorized the impossibility of the non-transition within settler colonial spaces, such as Canada. Liberal democracies like Canada have tried to deploy reconciliation, both as truth-seeking and reparation mechanisms that I'll get to contend with a distant violent past. Yet, as Coulthard argues, the erasure of Indigenous peoples from their traditional territories is not a singular event relegated to the past that can be atoned for through a process of reconciliation. Rather, the current settler colonial structure continues to perpetuate violence on a daily basis. My existence on these territories is part and parcel of that erasure. The infrastructure that we're all part of in this particular context was then built to make Indigenous peoples extinct. In 2017, Jeff Corntassel and Christine Bird chronicled the ways in which settler colonial Canada engages in practices of what they call serial killings of Indigenous peoples, and in particular, Indigenous women. Such a framing then requires the field of transitional justice to decolonize its animating features and recalibrate its foundational premises. Deploying transitional justice frameworks in settler democracies has recently led Augustine Park to suggest that paradigmatic transitional justice cannot contend with settler colonialism and that transitional justice as a framework can only be redeemed in the context of settler democracies through a radicalization that contributes to decolonization. This language of decolonization raises more questions than answers, I think. For example, what is the role of third world scholars in these processes of decolonization while loving, living, and working on these stolen lands? And here, what I mean is Canada. These types of questions, of course, are pertinent for racialized scholars housed within colonial institutions of higher learning, and that are engaged in training future lawyers. Lawyers and our profession were responsible for the creation of an apartheid-like system that has subjugated Indigenous peoples since Confederation in Canada. So let me leave reconciliation aside with that read and move on to the second theme that I want to explore, which is truth. If we can shift to the next slide, then I can start thinking or walking us through some of my thinking around truth. And I think truth is intimately connected to reconciliation. So to facilitate reconciliation, several national and international inquiries and commissions were created. Both instances of truth-seeking have their respective opportunities and challenges. These opportunities are underscored in Archbishop Desmond Tutu's words. And here I'm quoting him again. However painful the experience, the wounds of the past must be allowed to fester. They must be opened, they must be cleansed, and a balm must be poured on them so they can heal. It is to take care that the past is properly dealt with for the sake of the future. Notwithstanding these expectations, truth commissions have struggled to deliver on the promise of healing from a violent past. In my remaining time, I focus on these tensions by examining international truth-seeking mechanisms. From there, I'll move on to my third theme, which is reparations. So there are many different examples of international truth-seeking mechanisms that were deployed over the years. Investigatory bodies were created to examine causes of World War I, for example, and to investigate war crimes committed during the Second World War. More recently, United Nations bodies were utilized or the United Nations have utilized international commissions of inquiries as fact-finding missions. These types of investigative bodies were deployed in the former Yugoslavia and Rwanda before the United Nations Security Council created the two ad hoc tribunals. There are examples of commissions created to determine what happened with a particular territory, for example, Darfur, or to determine if criminal culpability needs to be adjudicated. Some of these commissions have recommended the creation of international mechanisms, while others have recommended an end to prolonged conflicts. These developments have then spurred on the growth of a body of scholarly engagement that critically examines these international fact-finding mechanisms. I think we should move to the next slide. In a powerful critique of international human rights fact-finding missions, third world approaches to international law, or TWAIL scholar Professor Obriora Okafor pointedly argues that these international fact-finding processes are plagued by several problems. Amongst the 7 problematic framings Professor Okafor identifies, 2 are noteworthy for my purpose. He argues that the third world is conceptualized by these inquiries or these truth-seeking commissions as horrific places akin to hell. Such a view of the location of the inquiry then poses a challenge for how victims and the events are conceptualized and described. Okafor, moreover, identifies the one-way traffic paradigm of the fact-finding inquiries that follows from this binary logic of heaven and hell. In this paradigm, he says, human rights knowledge, scrutiny, and supervision tends to flow from those parts of the world that supposedly invented human rights, for example, the West, and that observe it almost perfectly to those regions of the world that tend to know very little, if anything, about it, i.e. the third world, and that hardly ever observe it. And so this encapsulates my second read of one of the themes of transitional justice, which is truth. Now I want to shift to the third theme, which is reparations. And if we can shift the slides, thank you. So if we were to shift to reparations in the wake of mass violence may seem impossible. This is particularly true for societies reeling from large-scale human rights violations. For example, how does one compensate victims of genocide? How does one compensate a victim of torture and sexual assault during a violent conflict? What about compensation for slavery? These questions, however difficult, are at the core of any reconciliation process. Reconciliation is about understanding what happened and acknowledging the harm while atoning for the causes, as formulated by the findings of both the South African and the Canadian commissions that I cited to earlier. There are multiple means by which reparations are made possible domestically and internationally. Reparations may take the form of individual compensation for the loss of life, or it may be more symbolic, akin to an apology. There are numerous instances of state actors offering apologies for past harms. The elected heads of states of several Western settler colonial colonies have offered formal apologies for past historic harms. For example, in 2007-8, the former Prime Minister of Canada offered an apology to Indigenous leaders in the context of residential schools. Yet these types of apologies are meaningless to the victim communities if no substantive systemic changes are forthcoming. An apology may be part of the state's box-ticking exercise as a means to go through the motions of providing an apology without actually meaning it. In an alternative manner, Sarah Ahmed offers the following insight, which I thought was quite poignant. Ahmed notes, to apologize can be to say too much, to do too much, because of how apologies can be received as an admission of something, or as taking responsibility for wrongs, historic or not, whether intended as such. So in the remaining few minutes, I want to focus on the reparation process set up by Canada and Sri Lanka. The Canadian and Sri Lankan experiences are illustrative examples of domestic forms of reparations. There are numerous means by which reparations were made possible. In terms of resources, the Sri Lankan process, however, was stark compared to the Canadian. While the compensation was within the mandate of the Lessons Learned and Reconciliation Commission, the actual task of compensating the victims was left to another government agency, interestingly titled the Rehabilitation of Persons, Properties, and Industries Authority. In its analysis, the Lessons Learned and Reconciliation Commission did note that there was a lack of trust in state-based authorities, and victims were unmotivated to submit claims. The LLRC thus examined the possibility of compensation and noted that while the public authority that was tasked with reparations may have the statutory authority to provide compensation, it must, however, be adequately resourced. And here, this process of not adequately resourcing these kinds of commissions has a long history in Sri Lanka. And there's a long history of truth commissions that have been set up by the Sri Lankan state since 1947 when the act came into force. And I've written about this in a different context. And in a different context in early 1999, I actually sat through some of the testimonies that the victims provided to a different commission, and I participated, or I sat in the gallery and I listened to the victims as they testified before the commission for over 5 or 6 days. So, my critique of this comes from a large body of literature that already exists. Now, shifting to the Canadian context in terms of reparations, the Canadian federal government, approximately 80,000 survivors of the residential schools, churches, and other stakeholders like the Assembly of First Nations came to a negotiated settlement through the Indian Residential Schools Settlement Agreement. And this was part of the cloud case that I referenced earlier in the context of the Ontario Court of Appeal. This agreement was largely precipitated by the negotiations led by the Assembly of First Nations and the legal action taken by the survivors before the Canadian courts. The agreement includes 5 elements that sought to compensate various aspects of the victim's experience, or rather the victim experience. Focusing on the compensation for survivors, the agreement set up 2 different mechanisms for reparations, both of which were administered by the Canadian federal government. These are the common experience payments and the independent assessment process. The process of reparations instituted by the Canadian government was criticized, notwithstanding the compensation for the victims. The criticisms range from the behavior of the lawyers to the re-traumatization of the victims. In terms of the legal representation, the law societies, which are public bodies that regulate lawyers across the country, were criticized for allowing lawyers to chase after their potential clients. And here there's some literature on the type of ambulance chasing behavior that lawyers kind of participated in. Moving beyond the institutional and procedural problems, Anishinaabe legal scholar and band council member of Walpole First Nation, Dr. Valerie Wabuse, has chronicled the re-traumatizing effects of these schemes on the residential school survivors. If we can shift to the next slide, please. Through a survey of survivors and their experiences with reparations, Dr. Wabuse, or Professor Wabuse, suggests the following. For those that never or rarely ever spoke about this time in their life, the experience of being taken back to those painful memories for the first time was equally or more devastating. And in her work, Wabuse chronicles the ways in which Indigenous survivors had built up various coping mechanisms of forgetting some of the severe trauma that they experienced at the residential schools. And you know, the more I don't know if folks in the audience or are aware of this, but you know, some of the children that were killed at the residential schools throughout the country, they were buried nearby the schools, and you know, there was a whole there was an attempt to hide their murder, etc. And now we're in the process of exhuming some of the remains, and Canada has very recently started to kind of grapple with some of the ongoing impacts that the survivors are dealing with as well. So putting aside the financially motivated behavior of the lawyers in this process, Wabuse's, or Professor Wabuse's, articulation of the re-traumatization of the victims is an important one. While it is true that reconciliation requires truth, the stark reality is that the victims may be harmed through a truth-telling process. In the context of reparations, moreover, the victims are assessed based on the type of harm that they've endured, speaking to the 2 different types of schemes that we have in the context of survivors. This assessment is conducted by a public official, and the type of harm dictates the type of reparations. And funnily enough, as I was conducting research for another project in administrative law, I stumbled upon many bias claims against some of these public officials who did not believe some of the survivors, because the officials were not coming from the various Indigenous communities and did not have a full understanding of the gravity of the genocidal practices of the state and those that were implicated. So while there are ways to mitigate the harm caused to the victims, both the Sri Lankan and the Canadian examples illustrate the domestic challenges with dealing with a violent past. In Canada, the victims are expected to narrate their pain to receive compensation, while in Sri Lanka, the victims may narrate their pain, but there is no public purse that can dispense the reparations. And this is even more particularly true in the current context in Sri Lanka. Okay, so let me maybe take 30 seconds to conclude, and maybe we can shift to the final slide. So in this talk, I've sought to provide a critique of transitional justice through a reading of 3 of its central themes. Of course, there are other themes that I didn't get to, such as accountability, but I wanted to focus on these 3 because I thought it would raise some interesting and pertinent ways of framing things. So as an insider and an outsider to the field, I'm deeply humbled by the promises that transitional justice holds. In particular, I'm humbled by the energy that you've devoted so far to construct this field and build it as a way to move on from the violent past. But that said, I also worry about how we're achieving our goals, how we're treating the victims, and how we're thinking about the historical context in which all of the violence occurred. With that, let me say thank you again to the organizers for this opportunity to present this wonderful to present at this wonderful series. And yeah, thanks.
Wonderful. Thank you so much for that fantastic lecture. So many different kind of things that you covered and so many different elements. And I can see that we've got a couple of questions coming in already, but I actually wanted to take the opportunity to first ask my own, which is really cheeky of me, but I've been thinking about it all day. So I was very struck by the kind of some of the tensions in your lecture and in your paper, you know, thinking about, and you ended on being humbled by the kind of focus on transitional justice, but then also the problems of it that you've shown. There's also this kind of insider outsider that you note yourself as being related to in terms of the Canadian state, and then also kind of this focus on queer readings as the critique from the inside, which I really love, being a big drag fan myself. And I was kind of thinking a lot about how this relates to both transitional justice, but also TWAIL, or kind of critical work in public international law. And so I was thinking, you know, in some ways, TWAIL itself is at moments can use international law to try and change things, but by doing so is complicit in upholding some of the problematic structures of international law. And so I guess I was wondering if you could reflect a bit on how this relates both to TWAIL and to transitional justice. And I guess to kind of frame it in another way, you know, is the law itself inherently so violent that we should just abandon it? Thinking about Vanya Hamzik's work in particular here. So yeah, a big question to start you off with, but maybe we could start there if that's okay.
Thank you, Dr. Jones. And I'm really glad you raised that, right? Because for me, as I've kind of thought through, or as I've evolved from my initial phase in believing in the law and thinking that, you know, and here I think back to my days as I was learning how to become a lawyer, I had this firm kind of belief that the law was emancipatory. Right. And now, after 15 years of trying to kind of bang my head against a brick wall, I've come to the realization that the law is not at all productive. Right. And in fact, it reifies some of the arguments that we've been making, or let me move away from the language of reifying, but rather it solidifies some of the critiques that we've been making. And it entrenches it within the structures, right? And so in that sense, I think what you're alluding to vis-a-vis TWAIL is that, you know, there's a tension between TWAIL 1 scholars who thought that they can deploy international law as a way to create emancipatory potential for the racialized peoples of the global South, and then the TWAIL 2 folks, or the second wave of TWAIL scholars, who have tried to kind of think critically and more, you know, postmodern, and I'm not really wedded to that idea either, but, you know, we're in that sense of really thinking through the indeterminacy of the law itself. And, you know, here, one of the things that I find really useful is the work of Karen Mickelson in framing the third limb of TWAIL that's starting to kind of emerge, which is the hopeful register that's prevalent within TWAIL, right? That, you know, folks are wanting to kind of think about the fact that the system is really, really rigged in a particular way. And for me, as I sit here in the financial capital of Canada, which has the largest mining companies that are operating in the global south, in a condo complex 5 minutes away from Bay Street, this becomes really hard to ignore. Right. And for me, and that's where I think the work of the Indigenous activists like Leanne Simpson and Robin Maynard are useful, because they're thinking about solidarity in the context of Indigenous and Black folk, and to think through the ways in which we can abandon law and rebuild something through the resurgence of those communities, right? And so, while I think that you're absolutely right to kind of push me on this question of, well, shouldn't we just abandon this field of transitional justice, given its kind of really problematic ways in which it's kind of grown, or it has been generated out of. That said, I also think about the Argentinians and the Chileans and the Sri Lanka, the Tamil mothers, right, whose children were disappeared. And then, I as a lawyer, and this, I don't know if my colleague Vasanthi is in the audience, but, we often have this conversation because our offices are next to each other. And we often talk about this tension that, that exists in terms of the need to be a lawyer and provide that kind of remedy for the clients versus thinking about the structural stuff that we need to fix, and or should we just abandon it? And for me, in the context of international criminal law, I think that international criminal law should be completely abandoned, right? Given its structural problems, given all of the issues that we have kind of seen time and time again. And I don't know how many more times we need to say it. But with transitional justice, because it encompasses a variety of techniques, right? From apologies to various means of thinking about the past harm, I don't know, I'm still a little bit hopeful that there might be something that we can redeem. Anyways, I don't know, I don't want to go on for too long, but.
No, that's perfect. It actually leads quite nicely into some of the other questions that we've been getting in, which I'm going to group two together because they're kind of focusing on some of the, I guess, different ways of seeing transitional justice that are in existence in kind of practice. So the first question comes in from Neha Lashari, who says, I'm not sure if there's something you're familiar with, but in case you had any thoughts, could the very important issue with transitional justice you've discussed be resolved or at least somewhat ameliorated with a genuinely restorative justice approach to transitional justice? So that's the first one. And I wanted to add it in with this question from an anonymous submission, which asks to what extent you feel the move towards transformative reparations could address some of your concerns around systemic change or not. So I guess, yeah, restorative justice, transformative reparations. So I wanted to kind of question you on those.
Okay, and maybe is it possible to ask a follow-up question to the second person in terms of what do they mean by transformative reparations? Because there's many different ways in which we can think about transformative reparations. So I guess I'll kind of start, and then maybe if they can throw it in, we can from there. But I guess I guess these questions point to maybe reforming the system from within, right? And I think that's I think those are really interesting ways of thinking about the issue. And for me, restorative justice has come up in the context of that I've seen it come up in the context of sexual assault issues on campus, for example, right, in the North American context and in various other instances. And what I find really, really interesting and analogous to the issues that many have raised in the context of transitional justice is that it's structured by similar procedural processes, right? And so when you institute restorative justice mechanisms, are you drawing from Western notions of law, or are you drawing from Indigenous conceptions of law? right? And so for me, what I've noticed in the current context, in the context of maybe let's leave the sexual assault stuff out, but just, student misconduct. Let's just frame it as student misconduct. In the student misconduct context, when you start drawing from Western notions of law, then it brings with it the whole host of issues that we've already identified, ranging from bias of the adjudicator to the restrictions within the doctrine to the colonialist ways in which the doctrine was developed, etc. So you're now you're kind of transplanting, to use the language of legal transplants. You're bringing in all of those elements, right? So I guess that's my kind of attempt to answer the first question, which is to say, if the restorative justice turn is one that is predicated on Western notions of law, then I'm not so sure that it'll be that useful. Meanwhile, if we say it's going to be predicated on let's say Anishinaabe or Nihil, which is Cree conceptions of law, then it has to be structured along those legal orders practices, and it needs to include those people in this conversation, right? It's not something that I can go in and magically say, oh, suddenly I understand how Anishinaabe legal orders works, right? Just because I've participated in 2 sessions. And this is something that many of us have critiqued in the context of transitional justice, right? Where experts that go from one tribunal to another somehow magically get expertise because they have participated in these tribunals. So again, we need to kind of really think about the authentic ways in which the legal orders are being deployed, etc. Now, was there a clarification that that came in?
Yeah, so there was a clarification. They said they were referring to kind of gender work in particular, and then kind of inclusion of women through things like redistribution of property or police training as examples.
Yeah, and so I guess, if I was to think about representation, questions of representation, or training those that are prone to violence, then again, I think this comes back to my answer or my kind of response to the first question around restorative justice, right? And I think in this current moment, and this kind of leads me into some of the work that I'm doing right now around race. In this current moment, we're kind of infatuated with representation, right? We need to have that one queer person, that one brown person, that one whatever person that that's missing, right? And fortunately for some of us, or unfortunately for some of us, we sit in many categories, and so we can fit those boxes. But that said, I'm reminded of Zoroastrian Zeal's famous quote, which is "Skin folk are not kinfolk." Right. And this is the Clarence Thomas effect, right? You may be able to appoint someone on the bench or have representation in these kinds of spaces, but that does not mean that you're going to have the same kind of political outcome. And we saw that with the overturning of Roe and Wade, right? I don't think I need to go into all the details of how that happened, but I think we can see how representation becomes really, really problematic. And so for me, I think we need to kind of really be careful about what we mean by representation, who is being placed in these spaces, and something that's a little bit more nuanced. And in terms of the training, I don't know. I don't, for me, and I'm going to be super frank here, right? I have zero interest in trying to train the police, because I think the police should be abolished and they're a racist institution, and there's no way in which the police are actually going to do what they're supposed to do. And, those that might say to me, well, what's the alternative? Well, I don't know. We have to figure it out. We need to have a conversation. We need to think about it. And we need to have a much more robust discussion with all of the stakeholders. And I'm just one person thinking about this, right? So yeah, let me just stop there. Thank you.
Great, always good to end on abolitionism anyway. So we have a slightly different turn in some of the questions that are coming in now. So there's one from Maria Gelpi that I wanted to ask, which is specifically about Puerto Rico. So it says, while Rico is not experienced a post-conflict setting, nor does it operate under an authoritarian regime, it's also not considered to be a full democracy based on its relationship with the United States. The neo-colonial policies and austerity measures that have been imposed on the island during recent decades have systematically created a form of dependency on its colonial power. Do you believe that a transitional justice framework can serve and be applied to countries such as Puerto Rico who have yet to undergo a process of decolonization? So lots in that question, I think, there.
Yeah, and I guess with the United States, I tend to kind of be reluctant to kind of engage with it because I don't really have too much of its historical or a good grasp of the historical context. And I know a little bit more about the historical context in Hawaii rather than Puerto Rico, but let me try to kind of provide you an outsider rudimentary take at this response. And I think there are others who might be way more qualified to offer a more critical answer to your question. But I think that, in some ways, and there's a ton of literature that's out there right now on thinking about transitional justice and race in the context of the United States and whether it can be useful or not. And in a similar way, I think that the answer depends on what do you want at the end, right? And for me, I think that in some sense, I think Puerto Ricans should be considered Americans, right? Or in the vernacular of abolishing all borders, I think that this distinction between Puerto Rico and the United States is a really kind of racist way of thinking about the Puerto Ricans versus the quote unquote Americans. And so I don't know if that's useful. And maybe the first thing to do, or one first response to the question, might be to say, you know what, everyone should have the nation states or should have the protection of the nation states fully, right, without having a tiered system, etc. But then, in that sense, that may answer one question of giving rights to everyone, but then that forgoes the historical harm that has occurred. And so in that context, I think that it may be useful to have a transitional justice process unfold. But then it ultimately depends on what Puerto Rico or what the folks in Puerto Rico are trying to do, right? And where do they want to end up? And, if I was to shift a little bit and kind of go to one of my examples that I used in the Canadian and the Sri Lankan context, we know in the Canadian context, and Indigenous people have said this to us over and over and over again, and when I say us, I mean the settlers on their territories, give the land back and let us be, right? And give us back our resources and let us be. That's what they have clearly asked for. But there is a significant issue in that the two ships that were supposed to be, and here the language of the ships is, I'm borrowing it from a colleague of mine at the law school at the University of Windsor, Professor Beverly Jacobs. She frames it as when the colonizers arrived, the Indigenous folks had viewed them as having their own ship and the Indigenous people as having their own another ship that they were both traveling in parallel on the river of life. And that was how it was initially conceptualized, but now the ships have kind of become one. And so how do we disentangle that? How do we kind of think about moving forward in that context becomes quite difficult. And in that sense, I think that maybe listening to the voices of the Indigenous folks might be useful. But that said, I think in the context of Canada, it becomes really difficult because the Indian Act that was set out in 1867 and subsequent to Confederation has enforced a particular type of band structure on Indigenous peoples that does not respect their traditional authorities. So the voices that we are hearing from are not even the voices that represent the community. Right? And so again, it raises more questions of what do we do than actually providing us with answers. So, and I won't get into the Sri Lankan example because I think it'll get way more complicated. And let me just stop there. I hope that tries to answer your question, Maria. But anyways, and if you want a copy of the paper, I'm happy to share it. I'll put it up on academia.edu shortly. So once it's ready.
Great, thank you. I'm aware of the time, but I just wanted to ask maybe one quick question that's summarizing about 3 that we've had come in, because we've got quite a few that I won't be able to get to, if that's okay. So really broadly, I think what these people are all asking in the end is how could we do transitional justice differently? And some of them are asking for kind of quite practical examples. So some of them asking about kind of Indigenous perspectives in particular. So maybe we could kind of just go to that, if that's okay. And then I'll let you leave, promise.
Thank you. So in terms of how do we do transitional justice in a different way, I think, this comes back to the question around Puerto Rico, right? Or my response to Puerto Rico. One might be to listen, right? And this is something that has been really, really difficult for me as a lawyer, right? Because when I was trained as a lawyer in the UK, actually, I was told that, and I guess I shouldn't just blame it on my training, but I think it's also the profession entirely, that we as lawyers know better, right? We know much more than our clients, and I think that is also very pervasive within the international law context. Right. And so for me, one of the things has been, and it's been really challenging, because I occupy this insider-outsider perspective, and it's to engage in this reflexive exercise of being in the moment and having it be ongoing, and to learn by listening, right? Listen to the clients, listen to the victims, listen to those that are saying, look, this is what we want. And this has been really, really difficult for me in particular, because I know that the challenges that I can see all of the challenges we've had in the context of accountability, for example, right? But in the Sri Lankan context, for example, the mothers of the disappeared have said, no, prosecute them. We want them prosecuted. And is it all of the mothers of the disappeared who've said this? No, only some of them. And so how do we go about kind of thinking through these responses, right? And maybe if we had a much more robust conversation about the problematics or the challenges of prosecution, the costs of prosecution, the ways in which prosecution may not get you what you want, etc., then maybe the victims, the folks that are asking for it, might change their mind. But we need to have that conversation, right? And as lawyers, we think, oh, we know better. This is the way in which it should unfold. And this is something that I've learned quite profoundly in the context of some of the work that I've undertaken with Indigenous folks on these territories, which is, I know my lane, right? I'm going to stay in my lane, and I will wait to hear from them, because otherwise, I'm replicating the white supremacist practices that I've been challenging. And so, I guess that's one way of starting to think about how the practices of transitional justice is to ask, well, what do they want? And then maybe kind of think through some of those issues alongside the folks that you're trying to work with, right? And this is also and I'll end on this in terms of the practical stuff. One of the things that I found really difficult when I think back to my early 20s, when I was in the conflict zones collecting the data for a local human rights organization in Sri Lanka, in the eastern province, on the data ranged from collecting evidence on who was folks that had lost kids to maiming and all of that stuff. What ended up happening is that, yeah, we collected the data, but then the system, there's nowhere for us to use the data within the system. Right. And so while transitional justice to use Tishapu Madligozi's language, transitional justice folks are, while there's this tendency to act like entrepreneurs, we also have to accept the limitations of the field itself, right? The field is structured by the politics of the day. In Sri Lanka, we saw how the 2015 elections resulted in attempts to create a set of mechanisms, but within 4 years, those mechanisms were halted because the system or a new president came in and he halted all of that because he was one of the people who had committed the war crimes. Right. And so we have to kind of, as experts or as transitional justice practitioners, we have to think about our own role in this context. Right. Anyways, let me kind of stop there.
No, thank you so much. I mean, from listening, the complexities of listening, abolitionism, drag culture, we've covered so much. So I just want to take this opportunity to thank you. I think we have so many questions, so I'm sure you don't mind people emailing you if they have further questions that want to follow up, right? Yeah, so please do email, and yeah, just thank you so much. I'm looking forward to co-conspiring with you, as you said at the start, moving forward. But thank you for joining us.
Thank you for having me. Bye-bye.
Thanks, everyone. Bye.